The record in the matter of the state of Michigan versus Jessica Gardinas, 5-02253 and 5-02661.
Thank you, Your Honor. Cassidy Kachukas for the people appearing requesting permission to practice pursuant to MCR 8.120 with Jeffrey Bilby as my supervising attorney.
Good morning, Your Honor. Jacob Sartz, the fourth assistant public defender here on behalf of Ms. Gardinas. She's in custody. And may we approach briefly?
Yes.
Thank you.
Okay. Waivers.
Off the record. On the record in the matter of the state of Michigan versus Parish Snider, 25-01090. Appearance, please.
Thank you, Your Honor. Cassidy Kachukas for the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Snider, who is approaching and now will be standing to my right.
Today's date that was scheduled for a preliminary examination. This is for operating while intoxicated third offense. My understanding is that there is going to be a waiver to the circuit court. Is that accurate?
Yes, Your Honor. That is my understanding. It would be a way that the circuit court to enter the mental health court in 30.
Yes, that is correct, Your Honor. She has already been legally and clinically deemed eligible for the program. Thank you.
Okay, and Ms. Schneider, you understand your right to have a preliminary examination here in the district court, correct? You have the right to have the prosecutor establish that they have sufficient probable cause that the felony was committed and probable cause to charge you as the person who committed the felony. You understand that?
Yes.
You wish to unconditionally waive your examination?
Yes.
Is anyone threatening you to do that?
No,
Any coercion to get you to do that?
ma'am.
And you're doing it freely and voluntarily, correct? Your bind over date is going to be October 1st. That's the date the circuit court is going to receive the file from the district court, not a date that you need to appear at the circuit court, okay?
Yes, ma'am.
Your next court date will be a pre-trial, and your attorney will be made aware of that. Do you have any questions at this time?
No, I appreciate it. Thank you.
Bond was set at 3,000. A personal recognizance with random testing, looks like 1 time per week and 2 times ETG per month. That will continue. Any additional matters for the record?
Not for the people, Your Honor.
Not for the defense. Thank you.
You're all set.
No. Just, I'll let you know when you get next question. Okay? Thank you.
On the record in the matter of the state of Michigan versus James Bonilla, 25-02345. Appearance, please.
Thank you, Your Honor. Cassidy Kachukas for the people.
The black one on behalf of Mr. Vanilla, he's coming up. Just now, 15 minutes on the right hand side.
Mr. Bonilla has a preliminary examination scheduled for today. My understanding is that there's going to be a waiver to the circuit court. This is for a woman's assault, correct?
Yes, Your Honor. And the waiver, my understanding, the waiver is with consent to 3 added charges. Those added charges being a felony firearm, possession carrying with unlawful intent, and a felony firearm attached to the carrying with unlawful intent.
Felony firearm. What else?
Felony firearm attached with felony assault, carrying with unlawful intent. And then felony firearm attached to carrying with unlawful intent. And I'm pulling up the package.
I need you to speak up a little bit louder because your voice is dropping off. Have felony firearm attached to assault. I have carrying with unlawful intent. What was the third one?
The last one is felony firearm attached to the carrying with unlawful intent.
That's accurate.
Your Honor, that's correct, Judge. I talked to my client about the addition of the charges and also about waiver summary exam negotiations around the order.
I don't know why everybody's voices, maybe it's because we got fans running, but everybody's voice is really low. You gotta speak up, because I can't hear you.
Judge, we're gonna waive.
Okay.
We consent to what the prosecutor has indicated, adding the 3 additional charges. And I talked to my client about a prelim. He understands what a prelim is. We're gonna unconditionally waive.
Mr. Bonilla, how are you? I'm doing well. You understand that you have the right to have a preliminary examination. And at this time, as it stands on the complaint, you're being charged with 1 count of felonious assault. You understand that?
Yes, I do.
You have the right to have the examination. And at the time of the examination, require the prosecutor establish probable cause as to the assault. They would also have to then establish sufficient evidence to add these charges. You don't have to consent to that. You understand that? And you're willing to waive your rights and consent to these new charges being added, correct?
Yes.
Is anyone coercing you to do that?
No.
Any promises exchanged to you if you waive your exam?
No, yeah.
Bind over dates October 1st, as the date the circuit court receives the file from the district court. You do not need to appear at the circuit court. Why does everybody wait till I start talking and they try to explain to their client while I'm talking? Because you can't listen to me and to your attorney at the same time. It happens almost every time I get to this portion. I don't know why. And I'm going to explain it, so you can just listen to me because I'm talking. That's the date the circuit court's going to get the file from the district court, not a date that you got to appear in circuit court. Do you understand that? So your next court date will be a hearing or a pre-trial in the circuit court. Your attorney will be made aware of that. Do you have any questions at this time?
No, yeah.
Bond will continue. Any additional matters for the record?
And Your Honor, did the court want the pack codes for those offenses I do have?
Yes, you could put them on a sticky note. I've already passed the file over at this point.
Okay. Thank you. Nothing further from people.
You're all set. Mr. Silverthorne is in the building, correct? We have Gardinas here.
Yes, right.
Okay, these are the matters of the state of Michigan versus Jessica Gardinas, 25-02253, 25-02661 on appearances, please.
Thank you, Your Honor. Cassidy Kachukas for the people.
Good morning, Your Honor. Jacob Sartz, the 4th Assistant Public Defender here on behalf of Ms. Gardinas.
Today was the date and time scheduled for preliminary examinations. My understanding is we will not be running exams today. And that the defense is requesting an adjournment.
Thank you, Your Honor. Yes, the defense is requesting adjournment on good cause grounds. At this point, we are still awaiting some additional discovery, Your Honor. We respectfully request an adjournment of a couple weeks. Thank you.
That is accurate, Your Honor.
This would be attributable to the defense. Thank you.
Okay, we will get you new date. October 10th at 8:30. October 10th at 8:30.
Thank you, Your Honor.
Do you have any questions for the court today, Ms. Gardinas?
No, ma'am.
Any additional matters for the record?
Not complete, Your Honor.
Your Honor, there's also scheduled a pretrial for Ms. Gardinas' misdemeanor matter. Mr. Rowley is currently over at sobriety court. We've been awaiting discovery on that file. It's my understanding that we did just get the discovery on Ms. Gardinas' misdemeanor file. At this point, we just request that Your Honor set another pretrial for this. Mr. Rowley sends his apologies, Your Honor. He's over with Judge Buchanan's.
Okay, no problem. That will be reset.
Thank you.
All right, I guess not. Do October 6th at 10:30. That will be October 6th at 10:30? Yeah. At 10:30.
October 6th at 10:30.
That's correct.
Thank you, Your Honor.
Thank you. You're all set, Ms. Gardinas. Let's see, we need to bring someone else up. We can bring up Jamiya Myers. She should be on Polycom. Wait a minute. She should be on Polycom. Miss Schroeder, what are we doing with Mullins? It's about, are we continuing?
Yes.
Do you need him brought up?
He's somehow.
Oh, he's gonna be on Zoom as well. Okay. He's there. Who else is downstairs? Hogan? We can bring Hogan up. On the record in the matter of the state of Michigan versus Jacob Mullins, 24-03520, 25-00212, appearances, please.
Thank you, Your Honor. Cassidy Kachugas for the people.
Morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Mullins. Mr. Mullins appears by Zoom, myself here in person.
This matter is scheduled for probable cause conference today. The exam is scheduled for October 3rd. Are we continuing to exam?
Yes, Your Honor. It's my understanding that we're continuing to examine this time. I will be in discussion with my office to see if we can come to a offer that we will result in waiver, but at this time, there is no offer to put on record.
That is all correct, Your Honor. Thank you.
The court is in receipt of a letter from Mr. Mullins. Did you all get a copy of it?
I
I did.
checked to see. I don't believe I did.
We'll make sure you get a copy.
Thank you, Your Honor.
Okay, so we'll see Mr. Mullins in person October 3rd at 9:30. Mr. Mullins, do you have any questions for the court?
Propose the motion to address bond, please, Your Honor.
Excuse me?
I'd like to do a motion to address bond, please, Your Honor.
Absolutely.
Your Honor, Mr. Mullins has been in custody for quite some time now. I do realize that there are serious allegations here. However, he was deemed as competent by the Forensic Center, and those findings were entered by this court. His family is here. His mother and father are both here today, and indicated they have plans for what they would do with regard to, I guess, aftercare for from the jail. I did not get a chance to get that full information from them, but I would ask the court to allow him to have either a reduced bond or a PR bond at this time, just given how long he has been, and he did complete the assessment for forensic psychiatry. Thank you.
Just for the court's awareness, I have no objection to whatever the court would like to do with bond. I would leave it to your discretion, but just so the court is aware, the reason that there is not an offer at this time is because I need to discuss with supervising attorneys to determine what they would like to do, because it seems that there may have been a missed attempt or assault by strangulation or RNO causing injury on one of the officers. That's why there's no offer at this time. So I just wanted to make sure the court was aware of that.
There is a bond on the arson for 10,000 cash charity. is remanded on the other file because he failed to appear. And I'm trying to understand this.
There's a third file, Your Honor, but it is a misdemeanor file.
That's not before the court today. And this is for a controlled substance possession, police officer assault 2 counts. One is a police officer actually causing injury, the other one is police officer assault resisting obstruction. Until a bond of 5,000, 10% on 24-03520, and then 25000212, I'll amend the bond to 10,000, 10%.
On the 2-4 file, that was 5,000, 10%, Your Honor.
Correct.
And the other one was
10,000,
10,000,
10%.
10%. Thank
All other bond conditions will continue, including your reporting to pretrial services within 48 hours of your release. You're not to use drugs or alcohol. You are supposed to be testing. It says 2 times per week. And you're not to travel outside the state without prior approval of the court. You're not to have contact with the protected party in file number 212, which is a Daniel Mullins and Barbara Mullins. Are those the people that are here?
Yes, Your Honor.
Yeah, there's a no contact order.
We're not against them in the contact orders.
There's a no contact order.
What, got rid of it? The judge got rid of it.
I'm the judge.
I requested that was removed.
I was not removed.
But it be, please.
It's not going to be removed. There's an arson fourth, and
It doesn't meet arson standards. Got 1,000 links.
I don't even know why they're talking in the middle of my courtroom anyways, but there's a no contact order. So
Yeah.
that will continue until this matter is resolved. So the parties, the prosecutor and the public defender can figure out how they want to move forward on that. But the magistrate would want to enter the no contact order. I think it's reasonable, and it will make it stay in place until the time that this matter is properly resolved. Any additional matters for the,
Not for the Your Honor.
Not for the defense, thank you.
thank you, you're all set. And we gotta get you a copy of this letter.
Yes.
Mr. Mullins, you're all set.
Thank you, Your Honor.
You're welcome. This is Jamiya Myers. Is that Jamiya Myers? Or Jamiya Myers?
Yes.
Yes,
Are you ready on her matter?
I am not, Your Honor. I need to speak here. I've had communication with the prosecutor. I need to.
You can log in.
Thank you.
Mr. Sertz, what are we doing with Morica?
Your Honor, the defense is prepared to run up on their examination this morning, but if the witnesses aren't here, we'll move to dismissal. Thank you.
I have not seen the witnesses, Your Honor. If I'm maybe one final phone call to make sure. Your Honor, I have not been able to make contact with the witness at this time, so I understand the defense would like a motion to dismiss.
On the record in the matter of the state of Michigan versus Morica Rutledge, 25-02451, appear for the record.
Thank you, Your Honor. Cassidy Chufis for the people.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender here on behalf of Ms. Rutland. She's at council table. She's standing to my right.
Okay, today was the date scheduled for preliminary examination. My understanding is that the necessary witnesses failed to appear. How we proceeding?
Thank you, Your Honor. Defense at this time would move to dismiss. The defense is prepared and able to proceed this morning. If the people are unable to proceed respectfully, we request that Your Honor dismiss the charges at this time. I've explained to Ms. Rutledge that this would be dismissed without prejudice. Thank you.
Motion is granted without prejudice. I will get you a copy of the dismissal. The people who have the right to reissue.
Thank you, Your Honor.
situation.
Mr. Hogan,
Yes. This is gonna be a waiver, Your Honor.
on the record in the matter of the state of Michigan versus Joseph Hogan, 25-02175, appearance.
Christina Beta on behalf of the Attorney General, Your Honor.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Bogan, who is standing to my right.
Mr. Hogan is scheduled for preliminary examination. These are for counts of child support failure to pay. And are the parties both waiving the exam today?
The defense is, Your Honor.
Is it the prosecution's intent to waive their examination?
Yes, Your Honor. My apologies.
No problem. Is there an offer at this time?
There is, Your Honor. This was discussed with the defense attorney this morning. If the defendant pays a quarter of his arrearage or bond directed towards the front of the court, then we would ask the court for an 11-month delay. If the individual, if he pays half of it, then he would be able to plead to an attempt. If he pays all of the arrears, then he would be able to plead to a disorderly person.
That's complete and accurate, Mr. Garrett.
Yes, Your Honor.
Okay, Mr. Bogan, you understand your right to have a preliminary examination in this file? You understand the right to have the prosecutor establish that they have sufficient probable cause that the felonies being alleged were committed and probable cause sufficient to charge you as the one who committed those felonies, correct? You wish to unconditionally waive your exam? Is anyone threatening you to do that?
No.
Any promises if you waive your exam?
No.
The bind over date is October 1st. That's the day the circuit court will receive the file from the district court, not a date you need to appear in court, okay? Okay, your next court date will be a pre-trial. And circuit court, your attorney will be made aware of that. Do you have any questions at this time? Any additional matters for the record?
No, Your Honor.
Not from the defense, Your Honor.
Thank you. You're all set.
Okay, thank you.
Thank you.
You can all the way up. You can call, okay.
On the record in the matter of the state of Michigan versus Daniel Trevino, 25-02620. Appearance, please.
Thank you, Your Honor. Cassidy Kachicas with people.
Good morning, I'm Wayne Sullivan from the Office of Public Defender. I'm going to Daniel Trevino, who I see is appearing on screen via Zoom.
Mr. Trevino has a assault with a dangerous weapon and a domestic violence that accompanies. My understanding is that there's been an offer extended that he wants to accept.
That is correct.
What was the offer?
Yes, Your Honor. The offer would be a plea to 1 count of domestic violence under the deferred sentencing. I won't say it's 7/7/11. For delay up to a year, the term of that being successful completion of the inpatient treatment that he is about to enter and has already applied for and been accepted into. And if he is unsuccessful in completion, but is making satisfactory progress, at that time, we can reassess whether we convert that to a conviction or dismiss entirely or convert to some other form of conviction. If that makes sense. I'm very all right. Not even last week.
Who was Angela Trevino? His sister?
That's his sister.
Why is she in my virtual courtroom?
Mr. Trevino has hearing in hand. That's why we were able to take the plea last week, but he also has some cognitive benefits that it was to assist. If you'd like to have her-
I'm not sure how she's going to assist.
Well, I'm not sure. And if you just assume that she will leave, I have no problem.
Okay, well, I'm gonna remove her from the virtual courtroom. She's gotta watch on YouTube if she wants to watch it live. There's also a Daniel Trevino, but it says he's a victim.
Daniel Trevino Jr. is the victim, yes.
Yes, that is correct.
And you mind if I put as per the record? That would be. Can't approach you.
I assume Jeffrey.
Oh, Jeffrey? Oh, sure.
Not quite.
Sure, I got it.
I can see that.
Thank you. Okay, and Mr. Trevino, you can hear us, correct?
Yes, Your Honor.
Okay, so the plea was for you to plead guilty to count 2, which is domestic violence. That there is under a delayed sentence, 771.1, if successful completion or satisfactory progress of your inpatient treatment. It says DMFA.
Oh, sorry, and the delayed sentences would get rid of so at plea, dismiss the felonious assault.
At sentence, because this is,
Sorry, no, at plea, dismiss the felonious assault. At sentence, dismiss the DP. If successfully completing.
this says successful completion or satisfactory progress of inpatient treatment, DMFA. What does that mean?
DMFA
Dismiss.
is dismiss felonious assault, but that is at the time.
That's not
of
what
plea.
this, well, that's what 'cause next year,
Yes,
you won't be here.
yes.
I gotta go by what's
Let me
on
go
here.
try to correct this.
That says if satisfactorily completed,
Yes.
then dismiss the felonious assault.
Let me-
Doesn't say anything about the DV.
I'm just gonna initial the
Yes.
change.
Okay. I don't, hopefully that will make more sense.
Okay, so it says here, upon successful completion or satisfactory progress of inpatient treatment, dismiss domestic violence at time of sentencing. Okay, if that's what you want to do, Mr. Trevino.
Yes, Your Honor.
Okay, raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, Your Honor.
Okay, you can put your hand down. You have the following rights that you would have to first understand, and then you would need to give up these rights if you'd like to accept the offer. There's someone over your shoulder. Why is that?
She is my sister. She's just helping me to make sure I understand.
Okay, you do have an issue with understanding the English language or what I'm saying?
No, Your Honor.
Okay, all right. And so the rights that you would have to give up first is your right to be presumed or considered innocent until proven guilty. You understand that you have that right?
Yes, Your Honor.
You have the right to maintain your innocence. And you have the right to take this matter to trial and require the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You understand those rights?
Yes, Your Honor.
At the time of trial, you have the right to still be silent and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses called to testify against you. You have the right to subpoena witnesses to your trial that will testify on your behalf. And then you have the right, again, to maintain your silence or waive your silence and testify on your own behalf if you like. You understand that?
Yes, Your Honor.
Is there anyone threatening you to get you to give up these rights and enter a guilty plea to the domestic violence?
No, Your Honor.
Has there been any promises extended to you other than what's stated here on the record to get you to want to waive your right to plead guilty?
Yep. I'm sorry, Your Honor.
Anybody promise, and it says, anyone promised you anything to get you to want to plead guilty to the domestic violence?
No.
Okay. Are you currently on probation or on parole?
No, Your Honor.
Okay, you understand that by pleading guilty to the domestic violence, it could result in a conviction that you may need to report to your current employer or to a future employer.
Yes, Your Honor.
It also could have impact on where you can travel or get immigration status.
Yes, Your Honor.
As to count 2 of domestic violence, how do you plead?
Guilty, Your Honor.
Is that because you believe you are guilty?
Yes, Your Honor.
Have a factual basis, please.
Yes, Mr. Trevino, I'm going to take you back to August 27th of this year. Were you at the location of 606 Baker, 1/2 Lansing, Michigan?
Yes.
Okay. Were you there, in fact, with your son, Daniel Trevino Jr.?
I'm sorry.
Were you there with Daniel Trevino Jr., your son?
Yes, sir.
Did there come a time when you and he got into an argument?
Yeah, Your Honor. Or, sir.
And not to go over the entire argument, that there also come a time towards the end of the argument where you chased him with a knife and threatened him with a knife.
Yes. That means I can state my statement?
I'm sorry?
Can I state my
I'm just
statement?
No. Did you chase him with a knife?
Yeah.
Thank you. And did you threaten him with a knife?
Yeah.
Thank you. I have no further questions.
Any questions from the prosecution?
No, Your Honor, I believe that should be a sufficient factual basis.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. And this matter will be set for sentencing. We do not yet have next year's calendar, so I will have to submit the notice of sentencing. It'll be mailed to the address that we have on file. Can you confirm your address, please?
That's directed you, Mr. Trevino.
You mean the address that I'm at right now?
Where do you want your mail to go? Because we won't be able to send you your notice for your next, for your sentence until after they upload our schedule for next year. So it might not be for a month or so. What address are you receiving mail?
Okay, I'm getting it right now. I apologize.
No problem.
I thought I had the information right here. Please forgive me.
Mr. Trevino, will you be at Elevate?
Yes, sir.
Would you like it sent there?
Yes, sir.
Yeah, I do have that address. I don't have it right in front
How
of
long
me,
is it
but
supposed
I
to be
can
at
send it to the
Elevate?
court. Pardon?
How long is it supposed to be at Elevate?
It's a program that can be a year up to 18 months. He can enter as soon as I verify with Elevate that he's entered a plea in this case. I would be happy to send that to the court yet this morning.
We'll note here that you'll provide an address to where his notice for appearance for sentencing will be. Any additional matters for today's record?
Your Honor, it's my understanding, I think the victim would like to it's my understanding he may be requesting that the no contact order be lifted, and I believe he's on the Zoom call this time. We'd like to discuss that with him.
May I-
Mr. Trevino Jr. Daniel Trevino Jr., are you there?
Yes, Your Honor.
Please start your video.
One moment. Sorry about that. I have not used this app before. I'm not entirely sure about how to turn on the video. My goodness. Give me one moment. I'm trying to turn the video on. Oh, thank you. There.
Okay. Okay.
I'm here.
Your name is Daniel Trevino Jr.
Yes, Your Honor.
Okay, and the defendant in this case is your dad.
Yes, Your Honor.
Okay, you're requesting to have the no contact order lifted.
Yes, Your Honor.
Okay, and you don't believe that there's a ongoing threat for your safety that you need to be concerned about?
No, Your Honor.
The no contact order will be lifted. Mr. Daniel Trevino Sr. is allowed to have peaceful contact with Daniel Trevino Jr. Any additional matters for the record?
Not for the people, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
I don't know how to do this.
You can be seated. On the record in the matter of the state of Michigan versus Jamiya Myers, 25-02663. Appearance, please.
Thank you, Your Honor. Cassidy Chukas with People.
Good morning, Your Honor. Jeffrey Ross, appearing on behalf of Jamiya Myers, who is appearing via Zoom from Uniontown Jail.
Okay, Ms. Myers is here today for a we're treating it at least as a probable cause conference. It's supposed to be an exam date. She was remanded on a bond violation pending hearing. How are we proceeding on the underlying matter?
On the underlying matter, Your Honor, people in defense have come to a plea agreement. If I may approach that is on the sheet.
Mr. Trevino back. Waiting room. Mr. Trevino is back in the waiting room. Do we know why?
You're not.
Mr. Trevino? You're free to go, sir. You were all set unless you had a question.
Thank you, Your Honor.
You're welcome. Okay, let's see. The offer on this matter is to plead guilty to count one, or says to one count of domestic violence. Dismiss the R&O and agree to no further upfront jail. Wasn't there an assault and battery on this?
Yes, it was originally an assault and battery, Your Honor. So it will be amended to a EV. Just because it's the facts.
Okay, and your client wants to plead guilty to the amended count 2 of domestic violence, correct?
Correct, Your Honor.
Is that correct, ma'am?
Yes, Your Honor.
Raise your right hand.
I'm sorry, what was that?
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
You can put your hand down. Okay, you have the following rights that you would need to both understand and then be willing to give up if you would like to enter a guilty plea to the domestic violence. First is your right to the presumption that you're innocent. So you're innocent until proven guilty. Did you understand that, ma'am?
Yes.
You have the right to maintain your innocence and take this matter to trial and require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes.
You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses or present evidence that you believe show defense to the charges being brought against you, and you can waive your silence and testify at your trial. You understand that?
Yes.
You want to give all of those rights up today?
Yes.
Anyone threatening you to do that?
No, Your Honor.
Has there been any promises or coercion to get you to plead guilty to domestic violence?
No, Your Honor.
Do you believe you're guilty of domestic violence?
Yes, Your Honor.
Do you understand that by pleading guilty that it could result in a conviction that you might need to report to your current or future employer?
Yes, Your Honor.
It also could have impact on where you can travel or get immigration status. Do you understand that?
Yes, Your Honor.
Okay, as to amended count 2 of domestic violence, how do you plead?
Guilty.
Factual basis, counsel?
Yes, Your Honor. On September 2nd, we were at 1021 Orchard Street in Lansing. Can you hear me?
Yes.
On September 2nd, were you at 1021 Orchard Street in Lansing?
Oh, yes, yes.
There with your brother Isaiah, is that correct?
Yes.
At some time in the past, you had lived with Isaiah, is that correct?
Yes, as children.
Okay. And you guys were having an argument, is that correct?
Correct.
and you threw a plan at him and hit him. Is that correct?
Correct.
And he didn't ask you to throw the plan at him, did he?
No,
And he didn't want you to hit him with the plan, did he?
no.
Thank you. I think that does it, Your Honor.
Any questions from the prosecution?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing November 13th at 9 a.m. She needs to meet with probation so that they can provide the court with a pre-sentence report about how she should be sentenced. I am going to require that she undergo a substance abuse assessment. Again, there's still the matter of the pending bond violations that she was advised of last week, were remanded into custody, failing to make reports to the court agency as specified by this court, failure to participate in substance abuse testing or monitoring as ordered by this court, and then failure to complete urinalysis testing 1 time per week. She was supposed to report to pretrial services within 48 hours of release, failed to do that. She was taken into custody last week and blew a .205 in the jail. So I'll reset her bond violation for the time of sentencing.
Thank you, Your Honor. Can we address bond? Well, no bond.
Be my guest.
Okay, I know we have a bond violation here. Ms. Evans was charged with a felony and now has been reduced to a misdemeanor. We have agreement of no upfront jail. I ask that you give her a bond, a reasonable bond, or something she can post.
The issue is not my willingness to give a bond.
I understand.
The issue is her willingness to comply.
I understand. And I have spoken to her on that, and she just explains to me, you know, again, like she did here, she was in a very bad state of mind. And
absolutely, with a .205 in court, you can't possibly be in the right state of mind.
And
she doesn't even look the same way she looked last week.
And I understand that, Your Honor, and that's why I think she can adhere to your bond and immediately go to pretrial services and do all the testing that this court asks.
Ms. Myers?
Yes, Your Honor.
What is your intent? I mean, there's no point in me giving you a bond if you're not going to comply with it.
Your Honor, I absolutely will comply, and I apologize. Like he said, I was in a very bad state of mind. It was a very, like, this whole situation should have never happened. And so I was in a very bad state of mind, but I absolutely will comply, Your Honor. I have my kids, I have things I need to attend, and I will report as soon as I'm released.
Okay, I'll reinstate her bond, which was originally 1,000 personal recognizance. There's still a no contact order with the Jamiya Myers. You are to be on GPS tether. I'm going to add a scram tether. That way I can test your alcohol regularly. Any violations, your bond is revoked. Do you understand that?
I understand.
Okay, your address, ma'am? Is that still on East Grand River?
Correct.
Okay, and your phone number still ends in 6308?
Correct.
Okay, you need to report to pretrial services at this court no later than Monday at 11 a.m. You understand that? I said pretrial services. You need to report to probation no later than Monday at 11 a.m. You understand that?
I understand.
Is that going to be a problem with your work schedule?
No, it's not.
Okay, let's see. Any additional matters for the record?
Not for the people, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set, ma'am.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Thank you.
I'm done.
Was there, is Donald, Donnelly's downstairs? Is that what's going on?
Your Honor, yes, just Mr. Cheney, is ready to waive his exam.
Okay, you can be brought up.
Yeah.
Do you have Eloise Sweezy here? Oh, okay. State of Michigan versus Eloise Sweezy, 25-02677, appearance, please.
Thank you, Your Honor. Cassidy Chicas for the people.
Good morning, I'm Dwayne Silverman from the Office of Public Defender. On behalf of Eloise May Sweezy, who's appearing, standing to my right at the council table, I'm appearing for Ms. Wanji.
Okay, let's see. Today was the date that was scheduled for a preliminary examination. My understanding is that there's going to be a waiver of the timeline.
Yes, sir. For the people and especially the defense counsel have discussed getting Ms. Swayze to be screened for mental health court in 55th District Court. And so we asked that the 21 timeline be waived in order to facilitate that.
That's correct, counsel.
Yes, it is, John.
Okay, so the court will find her cause to adjourn so that she can undergo the screening. And we'll reset this. Let's start off with 30 days and see if they can have it done. This time of the year, when you start to get into like the fall, almost the holidays, the screenings take longer. For some reason.
To October 30th.
October 30th
At 9.
at 9 a.m. Any additional matters for today's record?
Not for the people, Your Honor.
Not for the appointment.
Do you have any questions, ma'am? Thank you. You're all set. Ms. Myers, you're all set. You can let the deputy know that you're all set and your PR bond was reinstated.
Okay, thank you.
Thank you. We can set it for exam. So what's your name?
Shane Young.
Did I accidentally post it? I didn't, I just skipped it. On the record in the matter of the state of Michigan versus Shane Young, 25-02638. Appearance, please.
Thank you, Your Honor. Cassidy Chicas for the people.
Good morning, I'm Dwayne Silverman from the Office of Public Defender. On behalf of Shane Young, who is standing to my right at council table. I'm filling in today for Ms. Wanji.
Thank you. Mr. Young was scheduled for an examination today. My understanding is that there's going to be a waiver of the timeline.
Yes, Your Honor. That's my understanding as well. Defense counsel has indicated that they may need some more time to review the body cam footage before we proceed to preliminary exam.
That's correct. I simply got this case yesterday, was not able to get a hold of Mr. Young. When I spoke with him this morning, he hadn't had his discovery yet. He hadn't gotten the initial filing there, which is as the incident. Additionally, when I looked into this file, these are two counts of resisting and obstructing. It seems like the entire case is probably caught on body cam, but there are a lot of body cameras. I have not had the time to review them. And so I informed Mr. Young that he wanted this to be able to look at these things as he is entitled to. He should probably schedule time with the form to do so, and then I would for the court to allow him to do that. He's out on bond. He's going to wait time.
You need to inform me to give him time to review his evidence. That's something you should do before you move forward in any direction. So I'm going to find the cause to adjourn this matter so that you can have an opportunity to further counsel with your attorney and go over the discovery and the video evidence. Okay? No problem. Do you have any questions?
No.
October 10th at 8:30.
Sure.
October 10th at 8:30.
Thank you, Your Honor.
No problem. Any additional matters for the record?
Not for the people, Your Honor.
Not from this minute. Thank you, Your Honor.
Thank you.
And good day, Your Honor.
Same to you. Melissa Morrissey, Ms. Schroeder left?
I see her in the hallway now.
I haven't seen, maybe she's talking to her client, maybe?
She may be talking to her client, or she may be in another court as well.
Say, I don't know if I see Melissa Morrissey.
Yes, Ms. Morrissey was trying to handle some matters of 55th and coming straight here.
Oh. On the record, in the matter of the state of Michigan versus Brian Cheney, 25-00249, FY, appearance, please.
Thank you, Your Honor. Cassidy Kachugas for the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Brian Cheney, who's standing to my right.
Okay, Mr. Cheney is scheduled for a preliminary examination today on receiving and stealing a motor vehicle. Are we running an exam?
No, Your Honor. It's my understanding that Mr. Cheney intends to waive his right to a preliminary exam. The people will also waive a right to preliminary exam to preserve an offer, and that there will be a determination, maybe a set going to the sentencing agreement.
What was the offer?
The offer is to plead to the the single count and dismiss the habitual offender notice.
Mr. Cheney, you understand your right to have a preliminary examination in the district court? You understand the right to require the prosecutor establish that they have sufficient probable cause that a felony was committed, and then sufficient probable cause to charge you as the person who committed the felony?
Yes.
Do you wish to unconditionally waive your exam?
Yes.
Anyone threatening you to do that?
No.
Any promises if you waive it?
No.
The bind over date is October 1st. That's the date the circuit court received the file from the district court, not a date that you are appearing in court, okay? Your next court date will be a pre-trial. Your attorney will be made aware of that, okay? Bond was set at 2,500, 10%. That will continue. Any additional matters?
Not with you, Your Honor.
Your Honor, I'm sorry, I forgot, because you wanted to address bond, right? You wanted to do that? I'm sorry.
I held on something?
I'm sorry, I don't have my computer on me. Mr. Cheney, do you have any other holds on you?
I got a hold in Clinton County for a traffic ticket.
For traffic ticket. Yeah, and then what you do have is, no, you don't have probation.
No.
No, you just have, this is it.
Yeah.
Yeah,
And I
okay.
got called on October 20th at 1:30 for misdemeanor.
Yes. So Your Honor, if there was any way we could, at this point, get a personal cognizance on that, that would be, that's all.
And if you would leave to the court discretion. you can argue.
On the minutes, 2,500 personal recognizance, all under other bond conditions will continue. You need to contact pre-trial services within 48 hours of your release, okay?
And
You're all set.
Your Honor.
Thank you.